Welcome to the LGBT Non-Discrimination in the Federal Workplace Gender Stereotyping Training. I would now like to turn the conference over to Mr. Bill Skaggs, Senior Training Coordinator with the Office of the Assistant Secretary for Civil Rights. Please go ahead.
Thank you. Hello, everyone. My name is Bill Skaggs, and for the next hour or so, we're going to be talking about LGBT non-discrimination in the federal workplace, gender stereotyping. As many of you probably know, this topic was selected by the Assistant Secretary for Civil Rights as the FY 2015 mandatory civil rights topic. And the reason is because it has become a very important issue in terms of civil rights. Recently, what has happened is that the definition of sex discrimination has changed. And under current Title VII case law principles, discrimination based on gender identity and transgender status is now considered discrimination based on sex and covered under Title VII. And in some circumstances, that same type of protection is being given to members who are gay, lesbian, and bisexual. And we're going to be spending the next several minutes talking about that. I think it would be helpful to note that the Civil Rights Act of 1964 included race, color, religion, sex, and national origin. Other protections were added later that addressed age, disabilities, and things like that. But there is no mention of sexual orientation or gender identity in the original law. And in fact, today, there is no federal law that covers sexual orientation in terms of employment protections. However, through legal interpretation, that has changed, and certain protections are now being made available to members of the LGBT community, and that's what we're going to be talking about. We're going to be going into some basic definitions that I think we all need to know before we can have this type of discussion. We're going to be talking a little bit about the history, because I think history is important to define where we came from to how we've gotten where we are today. Then we're going to be looking at some very recent cases that are going to give some real-life examples of what's considered discrimination now under gender stereotyping. And then we'll talk a little bit about workplace guidance, things that we need to be aware of to make sure that we don't have any issues in the federal workplace. When you take a look at protected bases, you've got those that are covered by the Equal Employment Opportunity Commission, those that are enforced by the EEOC. And as you can see on the slide, there is a number of them. There's also bases that are offered under USDA, things like political beliefs and affiliations, marital status, limited English proficiency. You'll notice that there is one under EEOC called sex stereotyping, and it's in red on this slide. And if you take a look under the USDA column in red, it talks about sexual orientation. These are the things we're going to be talking about today because under current case law, sex discrimination now includes gender identity and sex stereotyping, which is under the EEOC enforcement category. When you take a look at things covered by USDA policy, sexual orientation, it's also possibly covered under sex stereotyping, which is handled by the EEOC, and we'll be talking about that in more detail. So let's start talking about some basic definitions. First, sex discrimination. Just what is covered under EEOC's definition of sex discrimination? Well, basically it involves treating someone unfavorably because of that person's sex, and the law forbids it in any portion or any aspect of employment, including interviewing, hiring, firing, promotion, things like that. Sexual orientation. Sexual orientation is basically who we are attracted to. Heterosexual, homosexual, bisexual, everyone has a sexual orientation. It's not a conscious choice that can be voluntarily changed, okay? Gender identity. Gender identity is how we perceive ourselves as being male or female. Most people develop a gender identity that matches their biological sex. However, some people do not. People with a gender identity that matches their biological sex are called cisgender. People with a different gender identity or a gender identity that is different from their assigned sex are called transgender. So gender identity has two subtypes, cisgender and transgender. Gender expression is how we behave, how we present ourselves with regard to societal expectations of gender. It refers to all of the external characteristics and behavior that are socially defined as either masculine or feminine, such as the way we dress, how we groom, our mannerisms, our speech patterns, and our social interactions. It's very important to know that a person's sexual orientation is a very distinct thing. It's totally different from a person's gender expression or gender identity. Transgender. This is the T in LGBT. Transgender is a term that covers a broad range of people, a broad range of experiences and expressions in terms of gender. Okay? It includes people who describe themselves as transsexual, cross-dressers, drag queens, drag kings, or any non-conforming, gender non-conforming individual. Again, it is an umbrella term describing a lot of different expressions, and we'll be talking about a few of these expressions in a little bit more detail now. First, cross-dressers. Cross-dresser is someone who occasionally wears the clothing, makeup, accessories associated with the opposite gender. A good example of someone who is a cross-dresser is Dennis Rodman, basketball player. Drag queens, drag kings are someone who will basically dress in the gender that's different from their biological sex, except they typically do it for entertainment purposes. A perfect good example of that would be RuPaul. I think everybody's familiar with RuPaul's drag race show. And if you want to know why she does it for entertainment, I believe she's now in season 7, making $50,000 an episode. So, yes, that is definitely entertainment. The third category is transsexual. And transsexual is very different from the cross-dressers or the drag queens and drag kings definition that we had a minute ago. Someone who is transsexual, their gender identity and their birth assigned sex do not match at all. The term transsexual is typically affiliated with medical definitions. When an individual has a gender identity that does not match their birth assigned sex, it's typically called gender dysphoria, and someone who has gender dysphoria is considered transsexual. A transsexual is someone who will generally start living full-time as a different gender than the one they were assigned at birth. And some will actually seek medical intervention through hormones and/or surgery to make their gender identity and body match. very, very different from somebody who is a cross-dresser or somebody who is a drag king or a drag queen. For example, a person who would be considered a transsexual would be Chaz Bono, formerly known as Chastity Bono, who was the son of Sonny and Cher. The process by which an individual will change gender is called a transition. And the transition is a very, very complicated process. It is a medical process that has specific standards of care that's supported by the AMA and the APA, the American Medical Association and the American Psychological Association. Individuals who are in transition may start to take hormone therapy, may select reassignment surgery, and other type of medical procedures to make their living in a new gender more complete. The term sex stereotyping is basically when we don't act or appear according to societal expectations defined by gender, and when that is used against us in a discriminatory fashion. When we don't conform to a person's expectation of how a man should look or act, or how a woman should look or act, that is called sex stereotyping. And we'll talk more about that in a legal sense in a few minutes. So let's take a look at the historical timeline dealing with LGBT employment discrimination. I think looking at history is important because we basically are the past, and we are the sum of all of the events that have happened before, good, bad, or indifferent. So I think a little review here would be helpful. And that review actually starts prior to 1978. To the left of the screen, prior to the passage of the Civil Service Reform Act. Back in the 1940s and 1950s, if you remember high school history, there was a period of time known as the Red Scare in the United States, when there was an effort to identify and eliminate members of the Communist Party from the federal government. There were congressional hearings and all sorts of activities that took place around that. At the same time the Red Scare was going on, there was another scare called the Lavender Scare. And the Lavender Scare was directed not at communists, but at people who were gay, lesbian, or bisexual. Starting back in the Truman administration, enhanced under the Eisenhower administration, it was an attempt to identify people who were gay, lesbian, or bisexual that worked in the federal government and fire them. That was called the Lavender Scare. The FBI was actively involved. Hoover initiated their Sex Deviant program, which actively looked to identify members that were gay, lesbian, or bisexual that worked in the federal government. A lot of different estimates, but in terms of the number of people that were impacted, but several thousand folks lost their jobs because they were considered gay, lesbian, or bisexual. So that was called the Lavender Scare, and that lasted up until the Civil Service Reform Act of 1978. The Civil Service Reform Act of 1978 basically said, you know, there are certain things that you cannot be fired for, things that have nothing to do with your employment, for example. The Civil Service Reform Act identifies what is known as prohibited personnel practices, and one of them says that you're not going to be terminated for non-merit-based personnel actions. So you're not going to be terminated just because you're gay. OPM actually takes a look at the Civil Service Reform Act and considers it one of the first federal-wide protections for gays and lesbians. So that's why we're starting the timeline there, because that's pretty much the first protection that was ever given to someone who was gay, lesbian, or bisexual. but even though it doesn't specifically mention it. There are other cases along the way. Price Waterhouse in '89, which was the first time the term sex stereotyping was used, and we'll talk more about that in a minute. The case of Uncali versus Sundowner, which expanded the definition of sexual harassment to include same-sex sexual harassment. EEO 13087, executive order signed by President Clinton, which prohibited discrimination in the federal government based on a person's sexual orientation. Landmark case of Macy v. Holder, which dealt with transgender status. And then recently, just this past year, Executive Order 13672, signed by President Obama, which added protections to transgender individuals for the federal government. And we'll talk about some of these cases in detail right now. The first one is Price Waterhouse versus Hopkins. Ann Hopkins was an outstanding employee with the firm Price Waterhouse and had received a number of glowing reviews, and her customers, her clients really liked her. And there was an opening at Price Waterhouse for a partner, and Ann applied, and she was denied. She was turned down for that promotion. And she asked why. And the folks at Price Waterhouse, very open, and they told her, well, you're just a bit too macho. If you took a course at charm school, walked a bit more femininely, talked more like a woman, dressed like a woman, wore more makeup, maybe had your hair styled, maybe you wear some jewelry, we would consider you for the job. That course, that actually wound up at the Supreme Court, and that's when the term gender stereotyping came out, basically saying that you can't take your expectations of how a woman should look, act, talk, and impose them on somebody else, and by doing so, discriminate. So the term sex stereotyping, gender stereotyping, came out of the case Price Waterhouse v. Hopkins back in 1989. Uncali versus Sundowner dealt with an individual, Joseph Uncali, who was working for Sundowner Offshore Services, which was an oil company. They ran oil rigs in the Gulf of Mexico. And Uncali was part of an 8-man crew, and for some reason, Uncali was perceived to be gay and started to be harassed by his male coworkers. And he complained, and his supervisor refused to do anything about the harassment. And the harassment continued to get worse, and it got to the point where Uncali became very fearful because someone told him he was going to be raped in the shower. And so he quit, and he filed a discrimination complaint. And initially the complaint was dismissed in the courts because same-sex sexual harassment just didn't happen. When you talked about sexual harassment up until that time, you were dealing with male to female. But the Supreme Court disagreed, and the Supreme Court said, there is such a thing as same-sex sexual harassment. You can have men sexually harassing men. You can have women sexually harassing women. You can have women sexually harassing men. And so a major case because it opened up and changed how we look at sexual harassment claims under sex discrimination, Title VII. Smith versus the city of Salem, Ohio. Jimmy Smith was a lieutenant in the fire department in the city of Salem, had been with them for 7 years, and Mr. Smith was diagnosed with gender dysphoria. He was transsexual, and he announced that he was going to begin transitioning from male to female, and started to get harassed, and his supervisors determined that this was a perfect time to terminate him, based on the fact that he was going from male to female. Filed a complaint, went up to the appellate division, and they basically said that Price Waterhouse said that you can't discriminate against women because they don't look like a woman in your view. Well, the same thing applies here. You can't discriminate against a man because he's now starting to look more like a woman. Okay? The big case that talked about transgender is Macy versus the Department of Justice. In this particular case, the agency that was involved was the Bureau of Alcohol, Tobacco, Firearms, and Explosives, which is part of DOJ. Macy, while still known as a male, requested and received a transfer within Alcohol, Tobacco, Firearms, Explosives. Right before the job transfer went through, while undergoing a background check, she told them that she was transitioning from male to female. 5 days later, the agency informed her that the position was no longer available. They weren't going to fill it. And she found out after the fact that they filled it with somebody else. So she filed a complaint, and her complaint basically said discrimination based on sex, gender identity, and sex stereotyping. So the agency accepted the complaint based on sex for Title VII processing. The others, gender identity stereotyping, they were going to do through their internal process, non-Title VII. And the EEOC got involved and said no. It's all Title VII processing because gender stereotyping, discrimination based on gender identity, we consider that to be discrimination based on sex. So a person's transgender status now falls under Title VII sex discrimination protection. Okay. Since the Macy decision, there have been some other cases that have come up that have expanded the definition of gender identity a little bit more. It's expanded the definition to include people who are gay, lesbian, and bisexual. A person's sexual orientation by itself is not covered under Title VII sex discrimination. But if you discriminate against somebody who is gay, lesbian, or bisexual because they act differently than your gender stereotype of them, it is covered. And here is a perfect example with Veretto versus the U.S. Postal Service. Veretto was planning to marry another man. And as happens, you put your wedding announcement in the newspaper. One of his co-workers saw the wedding announcement that he was going to marry another man and began to harass him on the job because men don't marry other men. Men only marry women, okay, which is part of this gender stereotyping idea. And because of that, in Veretto versus the U.S. Postal Service, they're saying that based on the sex stereotype that only a man should marry a woman, that type of discrimination is discrimination based on sex, and it is covered. Does that make sense? Very similar with Costello. Once again, broadening that definition of what falls under gender stereotyping. In this particular case, Cecile, known as C.C. Costello, was subjected to a lot of discriminatory harassment, and the EEOC says it's harassment because of gender stereotyping. Okay, so guess what? It's covered under sex discrimination Title VII. And then finally, Couch versus the Department of Energy. In this particular case, Mr. Couch was subjected to a lot of different types of sex-based harassment. So guess what? It falls under that gender stereotyping umbrella again. So there are instances where discrimination because you are gay, lesbian, or bisexual falls under the transgender protection of gender identity. Okay? So how does this apply? For transgender status, according to the Equal Employment Opportunity Commission, discrimination against an individual because that person is transgender is definitely a violation of Title VII, and that discrimination is defined as directed towards somebody who is transitioning or who has transitioned to another gender, okay? So transgender status, according to the Equal Employment Opportunity Commission, is definitely covered under Title VII. For sexual orientation, it may be covered. It depends on the circumstances. Okay, like we saw with those last three cases, depending on the circumstances, harassment based because the person's gay, lesbian, or bisexual may be covered. And as a result, the EEOC has put some things together that talks about specific examples of what they consider to be illegal harassment. A woman who does not dress or talk in a feminine manner, a man who dresses in an infeminine manner, a female employee dating women instead of men, a male employee who plans to marry a man. Those are the type of things that definitely fall under gender stereotyping and are prohibited under Title VII sex discrimination. So, the EEO counselors, if you're filing a complaint and you're alleging you're being discriminated against based on sexual orientation, it's recommended that you check sex on the box in terms of discrimination. It's sex discrimination. They recommend you do that if it's a sexual orientation complaint. If it's gender identity, you must, because it definitely falls under that category. The Equal Employment Opportunity Commission has made it pretty clear in that they have yet to see a complaint of sexual orientation discrimination that doesn't fall under that umbrella of gender stereotyping, which is why they say you should counsel to check off the sex box. Okay? In addition to the Equal Employment Opportunity Commission, the U.S. Office of Special Counsel also gets involved in these types of investigations. Last year, the U.S. Office of Special Counsel sent out a letter that basically said, although we typically defer these type of discrimination complaints to the EEOC, we have the right and we reserve the right to investigate them if we deem necessary. Several months later, there was a huge announcement made that the U.S. Office of Special Counsel had found that the Department of the Army had engaged in gender identity discrimination, and they worked out an agreement for that. So in addition to the Equal Employment Opportunity Commission, the U.S. Office of Special Counsel also gets involved in dealing with these types of complaints. In terms of transgender employees, the U.S. Office of Personnel Management a couple of years ago issued guidance on how we are to handle an individual who is transitioning gender on the job. And the document that they put out covers 5 different things which are listed: confidentiality and privacy, dress and appearance, names and pronouns, the use of sanitary and related facilities, and record keeping. The information up here basically is this. If someone is transitioning gender on the job, that transitioning process should be treated as confidential, and those records are private. Typically what ends up happening is that as the transition progresses, the old personnel file is closed and a new personnel file is generated, because the individual, as they are transitioning, has to go to court to get a name change, has to go to the Department of Motor Vehicles for a new driver's license, that whole process. So the old file is eventually closed a new file is opened. Address and appearance is when the individual announces that they are transitioning. It's at that time that they should be allowed to dress reflecting their new gender. Names and pronouns, we have to make sure that the way we address the individual reflects the new gender. One of the things that the Office of Special Counsel found against the Department of the Army is they refused to do that and continued to refer to the employee in the old pronoun instead of the new. Sanitary and related facilities, once the individual transitions and is expressing a new gender, that is the restroom that they use associated with the new gender. And again, with record keeping, it's all confidential. And HR typically takes care of dealing with that whole process. But OPM has issued the guidance. That document is available for review if you want. So, what happens? You know, up to this point, we've been talking about the legal reasons of why we need to make sure that discrimination doesn't happen based on a person's sexual orientation or transgender status or gender identity. There's a lot of legal reasons, as we just talked about. But, you know, there's other reasons because, number one, it's just the right thing to do, to make sure that we have a workplace that's open and accepting where there's no discrimination at all. And if we can create that kind of a workplace, a lot of good things happen. We have a larger pool of employees, we reduce turnover, we increase productivity, and improves public image. So, you know, there's a lot of other reasons besides the legal reasons why we should be focusing on creating a inclusive work environment for LGBT employees in the federal government. Okay. Thank you very much.